that it is good. Okay, I'm asking you a different question, and the question is, how can it conceivably be in the public interest with 750,000 people yesterday, goodness knows how many today? I don't want to repeat myself, but you have the hospitalization figures growing by factors of 10 times what it was. You have hospitalization at the record, near the record. You understand the thing as well as so I repeat my question. To me, it's unbelievable, but I want to hear what you say. How can it be in the public interest, which is a requirement? How can it be a balance of harms in this case, assuming the arguments aren't off the wall on the government side, and believe me, they're not. Okay, that's what I want to hear the answer to.
Justice Breyer, states can act, private businesses have acted on historic levels. This is going to cause a massive economic shift in the country. Billions upon billions of non-recoverable costs. Testing also is not frequently available. This is in our appendix at page 374. Among those employers who have attempted to do so, only 28% are able to find adequate providers to ensure that weekly testing is available for the employees. If Congress intended to give an occupational health agency the power to mandate vaccines across the country, it needed to do so clearly. States can do it, businesses have done it and are able to do it. The question is not what is this country going to do about COVID, it's who gets to decide that.
Well, Mr. Keller,
maybe it's point, we can go with justice by justice. Justice Thomas, anything further? Nothing. Justice Gorsuch?
I do have a couple of questions, Mr. Keller. First, the government says that the major questions doctrine and federalism canon, for example, don't apply to this court's consideration of this case or any other unless the statute before us is first found to be ambiguous. What's your understanding?
Well, 2 points. If you need to even reach the question of whether there's ambiguity, and we think the term necessary is clear in context, it has to mean indispensable or essential, that would be a term where potentially the government in their interpretation would reach ambiguity. But regardless, the major questions doctrine is also in service of avoiding non-delegation concerns. And the non-delegation concerns that this court recognized in Industrial Union and citing
I'm sorry to interrupt you, but that wasn't quite my question. I apologize if I didn't make it clear enough. But the government says that we only consult those doctrines, the federalism canon, the major questions doctrine. I think the court understands what they are, but only consults them after finding a statutory ambiguity. Do you disagree?
I disagree in that the major questions doctrine is also a doctrine that would avoid non-delegation concerns. So even if there were a clear statutory term, non-delegation concerns in how to interpret that statute would factor in. Regardless, I think the term necessary here, there's plenty of room to implement the major questions doctrine there, in addition to all of the workplace tethered languages in the plain text and statutory context.
And then secondly, I would like to understand your argument and your colleague's argument from Ohio, I believe it is, why the court should enter a stay immediately. You asked for immediate relief. Why should the court grant immediate relief?
The short version is as soon as businesses have to put out their plans and this takes effect, workers will quit. That itself will be a permanent worker displacement that will ripple through the national economy. So we can talk about the billions in non-recoverable costs that the government even concedes, and we can talk about the lost profits and lost goodwill and lost business reputation, and we can talk about the businesses that are going to be put out of business. Our appendix at pages 375 to 80 quotes many businesses saying this would be catastrophic. It would bankrupt our company. It would be the most devastating event our company has ever experienced. That's why we're here. We're asking for an extraordinary stay. We understand the gravity of the situation, but in balancing the sheer size and scope of this emergency power that is supposed to be exercised delicately and the national economic implications of this when states and businesses can and have acted, we are entitled to a stay in this posture.
Justice Alito, sorry to have gone out of order there.
No, fine. Mr. Keller, I just want to make sure I understand what we should focus on here. Is the question whether this ETS is necessary to protect the health of the general public, or is it whether it is necessary to protect just employees, and not even all employees, but only unvaccinated employees, people who have chosen independently not to be vaccinated and do not want to be vaccinated. Is that the proper focus?
Correct, the latter, Justice Alito. As OSHA has said, the grave danger here is to the unvaccinated worker who's exposed to COVID.
Thank you.
Justice Sotomayor.